All right, everybody. My name is John Skiba. We're going to get started here. It's Thursday evening, time for our weekly live stream where we talk about debt collection lawsuits, wage garnishment, bankruptcy, and all the other horrible debt-related things out there, and some ways that you can deal with them. So I appreciate all those who have checked in today. Man, look at Dave Lamb right out of the gate. We got one of the a super chat there. Hey, Dave, I appreciate that, and you appreciate you supporting the channel. Let me start off by doing my weekly kind of disclaimer, I guess we'll call it. You may have noticed I wasn't here last week. I actually went on vacation. I was out of town. It's good to kind of get recharged and relax a bit. But now I've got it. Today's actually my first day back at work. And so now I've kind of had to change my get the fog of vacation down and get back into business. But so each week I answer questions on some of these debt-related issues. While I am a licensed attorney in the state of Arizona, I am not licensed anywhere else. And that means that I cannot provide legal advice to anybody in different states. What I'm providing here is just information that helps people who are dealing with debt problems. It's general advice. It should be taken just for that. It doesn't create any type of attorney-client relationship between us. There's no privilege between us. And so that's something that's important to know. If you need legal advice, you need to contact an attorney in your state because we've likely never met. I don't know the specifics of your case. I can just give you some general information about what this process is and some places where you can maybe find some of that information. So so how we do this is if you have a question that you want to discuss, you put it in the chat, the live chat stream there, and then I will pick a handful of them and I'll actually put it on the screen. And we'll discuss what they are and just kind of give you some of my ideas and some thoughts on it. So if you want a question answered, you got to put it there. But again, we're going to put it on the screen so everyone will see it. So as long as you're comfortable with that, I just want to let you know how that plays out. So, all right, why don't we go ahead and get started? Laura, who's also a regular here on Thursdays, I appreciate you checking in, Laura. You bought the awesome Motion to Compel Arbitration course. Thank you. For those of you who don't know, I have some online tutorials. I'll put a link here in the notes, but I do a lot of online tutorials that can walk you through in a lot more depth than what it is that I do here on my YouTube channel. They can show you exactly how this whole thing plays out. So I appreciate you, Laura, purchasing that. I put together a motion to compel arbitration, which is generally very helpful, particularly in junk debt buyer lawsuits. You says, I owe a response to some requests for admissions. How can I move the deadline until after the hearing, which is set for September? So requests for admissions. Let's back up a little bit there. Requests for admissions are a form of written discovery where the opposing party is sending over specific requests. They want you to admit certain facts. And these are super important because if you don't respond to them in most jurisdictions, if you don't respond to them timely, they are deemed admitted. So I've seen a lot of junk debt buyers who will take the approach where they will send over something like saying, admit that you owe, and they'll put the dollar amount, or admit that this junk debt buyer is the true owner of it. And then they do that knowing that most people don't understand that they have to respond to it, and then it causes problems. So that's what you're going to have to take a look at there. So as far as moving the deadline until after the hearing is set, that you can ask the other side to stipulate to it. The junk debt buyer is probably not going to do that, but you can ask them if they'll agree to it. If they do agree to it, it needs to be put in writing and notify the court. More than likely, what you should do is you can file a motion to extend that deadline with the court. You're going to have to put down why you want the extension and provide a reason, but a lot of courts will give some extensions of time on responding to written discovery. So that's one way to do it. All right, look at Jeremy. Thank you, Jeremy. I appreciate, or Jerry, I'm sorry, messing that up already. Jerry, thank you for supporting the channel here. All right, let's see some other questions. Let's go with Dave. Dave, I missed you guys last week. Thursday night, I was packing, getting ready to go. We went up to the lake with the kids, and it was awesome. 341 meeting was March 17th, but still waiting on the discharge. Clerks down in Yuma, they must be busy. Well, let me tell you generally so the 341 meeting, and this is in a bankruptcy context. This is the meeting of creditors. If you file a Chapter 7 bankruptcy, there's one meeting you have to go to with the bankruptcy trustee where they're going to ask you some questions. Your discharge is usually entered 60 to 90 days after that date. So we're recording this here on June 3rd. So yeah, it's not out of the ordinary that it's taking that long. One thing you got to make sure you do is make sure you have taken and completed the second financial management course, the online course, because if you don't complete that, they will not enter the discharge. So that's important to get that squared away. All right, let's go with one with Angie. What's the trial? It's probably trial. I'm assuming that's a typo. The trial scheduling conference. It is kind of what it kind of sounds like. This is really the time where the court will bring the parties in. This isn't a debt collection lawsuit. If they set it for a pretrial conference or a trial scheduling conference, this is where the court will bring the parties in. Now, kind of in this COVID era, a lot of this is being done over the phone or over Zoom, and they will schedule the actual upcoming trial. They'll also talk about deadlines to complete written discovery of either parties providing that or to even file motions for summary judgment. So that is it's kind of a scheduling thing. It's more of just logistics. It is important you attend, though, because in some jurisdictions, I can tell you if a party doesn't attend this meeting, they can actually result in judgment being entered. I know that in the Arizona Justice Courts, that happens routinely. So I always say showing up is more than half the battle when it comes to this kind of stuff. So making sure that you do that. All right, let's go here. Let's talk with Darwin here. Can you and your spouse file bankruptcy at the same time? The answer is yes. You can file as a joint couple. And one thing that a lot of people don't realize is you don't have to, like, one spouse doesn't have to file. You don't both have to file. I'm not going to go into the logistics of who should and who shouldn't file as far as if there's a married couple. But if you're in a situation where both spouses do not want to file bankruptcy, but one does, you should talk to a bankruptcy attorney in your area and just kind of discuss some of the kind of pros and cons of that, but it's possible. But generally, I can tell you most married couples do file on their own or file together. So the answer to your question, Darwin, is yes, we can absolutely do that where the bankruptcy is a joint case where you disclose all assets, all debts that are in the marital community there. So absolutely. All right, let's see what other comments we have here. This one, you've answered. I want to file the motion to compel private arbitration. Is there a template? I will get you, I'll put the link. I get a lot of questions on the motion to compel private arbitration. I'll put a link here in the chat, and we'll also do one in the comments. So once this is done and it's up there, there'll be a little link there so you can go there and check that out. All right, let's do another bankruptcy question. I have my 341 meeting tomorrow. My lawyer was saying the proposal plan goes to the court and takes 6 months to approve. So it sounds like what this is a Chapter 13 bankruptcy. So when consumers file bankruptcy, it's generally a Chapter 7 or a Chapter 13. Chapter 7 is a relatively short process that will take 4 to 5 months from beginning till discharge is entered. Chapter 13 is a much longer process. It is a 3 to 5 year process. And in a Chapter 13, you're required to propose a plan to the court and to your creditors on who you're going to pay, when you're going to pay them, how much, all that kind of stuff. So it sounds like what you're saying is whether it's Chapter 7 or Chapter 13, you've got to go to the meeting of creditors. They call it the 341 meeting. That's because Section 341 of the Bankruptcy Code is the section that authorizes these meetings. So that's kind of shorthand of, the 341 meeting. So the 341 meeting is separate and different from getting your plan confirmed. Now, that plan that you filed with the court and that you're proposing how you're going to deal with these creditors, the whole goal is to get that plan confirmed, meaning that you're okay with it, the creditors are okay with it, and the trustees okay with it, and the judge is okay with it. And once everybody's okay with it, it'll be confirmed. And that process can take 6 months. It can even take more than that. It just kind of depends on if there's any objections that have been raised to your plan or really kind of what you're trying to do there. So that's something that's not unusual. I know it's a little frustrating. It seems like this thing takes forever. Courts move slowly. That's one thing you have to know is everything about it moves pretty slowly. So, all right, let's take a look here. All right, let's take it. This is a good question. So, Belinda, today I received a voluntary dismissal letter from a junk debt buyer attorney. Can another junk debt buyer attempt to sue me again? Great question. So, now if a lawsuit gets filed, junk buyer brings it, and then there's two ways it can get dismissed. If you have not filed an answer yet, then they can file a request to dismiss, and you don't have any input into it. The court could just dismiss it, and it's generally dismissed without prejudice. Dismissal without prejudice means that it can be refiled again if it's not outside the statute of limitations. So if they filed the lawsuit and they decide for whatever reason that they're not going to go forward with it, and you have not filed an answer yet, then yep, the court will dismiss it. They'll dismiss it without prejudice, and then you're facing a possible refile down the road. However, if you have filed an answer in most jurisdictions under the rules of civil procedure, you have to agree to the dismissal, because essentially you kind of have skin in the game now. You filed an answer with the court. You paid your filing fee. You're involved in this process. And so the only way they can get it dismissed is by filing a motion to dismiss or getting you to sign a stipulation to dismiss. If they ask you to dismiss the case, you should say that you're only going to do it if it's with prejudice. You don't want this thing to come back again and have to deal with it. You've already filed your answer, paid the filing fees. Get the thing dismissed so that that it's done with forever and it's done. You don't have to deal with it down the road. So that's likely what's happening. It could be that there's something wrong with the case, that there's something wrong, that they don't have the evidence or the documents or whatever it is. But I mean, it's a good thing to get it released, get it dismissed, but you want to try to get it done with prejudice if you can. All right. Let's see here. This is another good question. If the plaintiff calls your bluff and takes you to private arbitration, is there a chance they can get you to pay the private arbitration fees? A lot of it's going to depend on what's in the arbitration clause as well, because that's really all the arbitrators are doing there. They're enforcing the terms of the agreement. So read the arbitration clause specifically to make sure exactly where it is. I mean, it's always possible there could be a term in there saying, hey, if you go there and you force arbitration and you lose, that they're going to add arbitration fees on top of it. I can tell you just in my experience, I have not seen them agree or even decide to push forward with the arbitration process. It's too expensive all the way up front. Maybe, on a very large account or something like that, I guess it's possible, but I just don't see that they're even really going to push it forward. But read those terms very carefully because that's what the arbitration process is going to be trying to interpret there. All right, let's talk about this one. Are affidavits admissible in a jury trial under the business exception rule of the hearsay? So this is a good question. So now what we're talking about here, so an affidavit is a written sworn statement. You often see this in junk debt buyer cases. They'll have some witness or some professional document person who will put out these various statements saying that they swear under penalty of perjury that all this is true, yada, yada, yada. And so the question here is, are those admissible in a jury trial under the business exception for the rule against hearsay? So hearsay is anything that's out of court. It's an out of court written statement that people are trying to have put into court. It can also be an oral statement. So often what we'll see, a good way to think about hearsay is if you're in court, you can't go up to the witness and say, what did so-and-so tell you? You have to bring in that other person so that it's firsthand information. The same thing applies for written documents like affidavits. An affidavit is an out-of-court statement. It's an out-of-court written statement, and so it's hearsay. So the only way it comes in is if there's an exception to that rule, and one of them is this business records exception to hearsay. It would not fall under the business record exception because affidavits are generally prepared just for the litigation process. So it's not a real business record per se. And so I would object to an affidavit coming into a trial. I've seen junk debt buyers try this a lot, where they bring the affidavit, they don't have their witness because the witness didn't show up or they don't want to pay for the witness to be there. And so they'll bring their affidavit into the court and try to say, hey, judge, just read over this. I always object. That's hearsay. It's an out-of-court statement. I don't know how it's not, a hearsay. It's completely hearsay. It's not a business record. It was created for litigation purposes. It wasn't created in the normal course of business. This is Rule 803-6 under the rules of evidence, likely in your state. So definitely, I would object to that. That's a good question. All right. let's see what else we have here. Let's look at this one. L. Anderson. Can a holding company or servicing company file a proof of claim when they're not the actual creditor? Do I have to have them in my plan because they file a proof of claim? This is, again, a Chapter 13 question, kind of getting into the weeds of it a little bit here. But so in the bankruptcy case, if you file a Chapter 13 bankruptcy, you're required to provide a list of all your creditors. You're also required to provide that Chapter 13 plan, like we talked about, where they will you're going to tell the court how much you're going to pay and which specific creditors are going to receive money through this process, and that there's rules in the bankruptcy code that require that certain creditors, like the IRS, is going to get paid, child support's going to get paid before, like credit card companies are going to get paid, that kind of thing. But if your creditors want to be involved in the process, they actually have to file what's called a proof of claim with the bankruptcy court so that they can basically say, hey, I'm here, we want to get paid through this process. Short answer is yes. I mean, a holding company or a servicing company can file the proof of claim on behalf of the original creditor. However, if they don't provide sufficient information, I can tell you with junk debt buyers, I have filed in bankruptcy on behalf of clients. I have filed objections to their claim because they haven't provided sufficient information for the court to be able to determine if it's a legitimate debt. So short answer, yes, they can do that, but you can also object to it if it doesn't look like there's been sufficient information, provided to the bankruptcy court to be able to justify some type of payment. All right, let's talk with Angie here. How is it legal that these junk debt buyers do? Seems like harassment and intimidation. I agree. It's kind of it's a very frustrating thing, and I get this question a lot. Like, how is it legal? And I even get a lot of comments in the YouTube channel. People saying, you know what, it's not legal. You didn't have an agreement with them. Here's the legal idea behind what it is that junk debt buyers do. It's perfectly legal to transfer the rights to payment to somebody else. So if a junk debt buyer, they want to, they're going to go out and say, hey, we're going to buy all these old charged off accounts. The law allows them to do that. They can go and they can pay whatever amount that they negotiate with the other person to buy that paper, to buy that right to payment. However, when they come into court, they have to be able to prove that they have it. They have to prove that your specific account was included in that transaction. I always say there's a difference between a junk debt buyer saying, hey, we think we're entitled to payment, and sending you a letter, that kind of thing. To me, it's a whole nother thing for them to come into a courtroom and say, we want a judgment. We want a judgment with all the powers that it has to garnish wages and bank accounts, and lien property, all that kind of stuff. We want a judgment. To me, a judgment means that they have jumped through all the procedural and evidentiary hoops that the court has put there to make sure that everything is as it should be before granting a judgment. And so that's why you got to hold their feet to the fire, because often, it's one thing, like I said, for them to come in and say that, hey, we feel like we're owed money. It's another together if they can't prove it. So that's why you've got to really press them, because yeah, it's legal. They can do what they're doing here. But at the same point, it's, they've got to be able to establish it. They've got to come in with legitimate evidence if they're going to do this in a courtroom setting. So, all right, let's do this. Hi, I received a demand for interrogatories. Do I demand the documents from them too? Great question. So interrogatories, this again is a debt collection lawsuit scenario. You're allowed to request information from each other and documents from each other. And there is these things called interrogatories, which are just written questions that you can ask. So if you have a question that you want to know from them, you can send over a written question. They have a certain time period to respond to it, and vice versa. So if they're sending you an interrogatory, you've got to respond to them to the best of your knowledge. As far as you demanding documents from them, this is where there's kind of a couple different routes you can go with this. With interrogatories, as far as documentation, let's go there first. As far as documentation goes, you can force them to provide documents. But I can tell you this, usually the less documentation that they have during this court process, the better off you are. They're the plaintiff. They bear the burden of proof. If they don't have sufficient documentation, the court should deny their case and throw the whole thing out. And so sometimes when you go and request a bunch of documents, they're actually having to go get more than they actually had from the get-go. And so it's one of these things where I've done it both ways in defending these cases. Sometimes I'll request additional documentation that they need to provide, and sometimes the fact that they don't have anything, I'll use that against them. So that can be used to the to your own benefit here. So, Alex, thank you. Every week you're here supporting the channel. I sincerely appreciate it. Down there in Yuma, especially this time of year, you guys are starting to. It's getting hot. I think it's 104 here in Phoenix today, so I know it's going to be hot there. But I really appreciate you supporting the channel. All right, let's see what else we have here. Let's see this one. If you have paid off a judgment for the amount agreed on in court, can the debt collector still come after you? So once a judgment has been paid in full, so if they went to court, they got a judgment against you, and now it's been paid in full, they should, in most jurisdictions, should be required to provide what's called a satisfaction of judgment document they file with the court saying it's done, everything's paid for. And so the question is no. If you've paid it in full as agreed, or you paid the settlement in full, they should not be coming after you. And it's a situation, if they do, you may have a claim against them under the Fair Debt Collection Practices Act. I'm going to be doing some videos, a whole series of them here in the near future on the FDCPA, the Fair Debt Collection Practices Act. This is the law that governs creditors and what they can and can't do. And you may end up having a claim against them, and they're going to be writing you a big check if they do something like this. So make sure that you keep good records. I see this a lot where people don't keep good records and they're not quite sure how much they paid. But if you get in a situation where you need to prove that you paid off what you agreed to pay off, you want to be able to use that, and then that could be used in that FDCPA case. So, all right. Let's see what else we got here. So this one here. Hi, I'm trying to decide if I should settle or pay in full. I'm hoping to move out within a year or two. Any advice? I always start with what can you do? Obviously, if you can pay an account in full, you're going to be in a situation where that your credit generally is going to be in a better situation than if you're just if you're settling it. But if it's something where you can't pay in full, and that's why you're in this situation, then reaching out and trying to get it resolved generally is the better thing to do, particularly if the account just recently went into collections. Because if you get it settled, what'll happen if you settle a debt, it'll then zero out that balance. It'll show that the account was settled for less than the amount owed, but it will be taken out of active collections. That alone is going to benefit your credit score considerably. So those are the kinds of things you need to take a look at. Really, is what is your situation? Can you actually do a settlement? Can you do a payment in full? And if you can't do a payment in full, then just try to get the best settlement you can, because it doesn't matter if you settle for 80% or if you settle for 20%. It's still just going to say settled in full. All right, let's see here. Let's do this one here. If I served a debt collector with discovery, should I also still serve them with a disclosure? Good question. In most jurisdictions, you have to do what's called a disclosure statement, where you are disclosing, each party is required to voluntarily disclose information about, not assets, but disclose information about documents or witnesses, legal theories, defenses. You're going to be required to disclose that information. The days of, Perry Mason surprising someone with something at trial doesn't happen generally anymore. You've got to disclose these things well in advance. So usually you need to look at the rules in your particular jurisdiction, because in most cases a disclosure is required. There's not discretionary. You have to do an initial disclosure, or you're going to be barred from using the information when it gets to be like a trial type setting. It's separate from the question of whether you should do written discovery. Written discovery can be a benefit if there's information you need or documentation you need that they haven't provided. That's when you would want to do that to get the remainder of the information. So, all right, let me follow up here with Belinda with this one. How do I request for a dismissal with prejudice? So if the plaintiff is saying, hey, I'm going to dismiss the case, and again, if you have not filed an answer, you're not going to have a whole lot of choice in this. They're going to just move the court to dismiss it, and the court will dismiss without prejudice. But if you have filed an answer, you have to give input. You have to agree to it. And so you could come in and say, I'm not dismissing unless it's with prejudice. And if they don't like that, then they can file a motion to dismiss on their own and ask the court. And then you could object to it, saying it needs to be with prejudice. So that's how you would do it. Is really, it could be done with them. If you filed your answer, you could file your stipulation where you're both agreeing to it, but you're only agreeing to it. You know, in exchange for you agreeing to it, they're dismissing with prejudice, that kind of thing. All right. I won't forget the forms. I'll put a link in the notes. It's hard for me to chew gum and do live streaming here at the same time. So I'll put that in the comments. If you want to check that, I'll do that before I go home tonight, and we'll get that squared away. So, all right. Hey, Marcos, thank you. What is the general time frame for a motion for arbitration to be approved or denied? In Arizona, a lot of you'll generally have. You think these questions would be really straightforward. So the general time, so if you file a motion, they will usually, if you're in superior court, they're going to have 14 days. If you're in justice court, you're going to have 10 days. Plus you generally get 5 mailing days on top of that. So I usually say roughly 14 days they have to respond to it. And then you can file a reply brief within 5 days. And then the court will make a ruling on it. So generally what you're looking at, if you file your motion to compel arbitration, you're probably going to get something within 30 days, something like that. So, all right. This will be the last one. Can the trustee look back on your bank accounts after you file Chapter 13? So one thing you need to recognize, if you file bankruptcy, your financial life is an open book. By availing yourself to that process, basically the trustees can really do almost anything they want as far as requesting documentation, requesting information about your finances. So they could look back. By filing on it, what most trustees are going to get at least a few months bank statements prior to the day that your bankruptcy case was filed, just to see if there's money that's being transferred around or what the balance of your accounts were at the time that you filed for bankruptcy. So those are the kinds of things that they're going to look at. So I always say, if you're in bankruptcy, you need to know that if they want bank statements, they're going to get bank statements. If they want information on transactions, they're going to be able to get it. So anyways, all right. And I said that was the last one. We'll do one more for Twisted here. I filed my answer about a month ago. Court is July 29th. Can I still file? Are you asking if you can still file for bankruptcy? If you filed your answer a month ago and the court's coming up, maybe you're asking for arbitration. Okay. If you're asking for private arbitration, go back and read the terms of the private arbitration clause. Most of them say as long as judgment has not been entered, that you can still file for private arbitration. So I would go back and take a look at it, but my guess is that you'd be able to do it. So, all right, that is going to do it for tonight. But I appreciate everybody chiming in and those who have done the super chats. Again, that's something I didn't even know existed until recently, but people can do that where you see that some people have donated some money. That does help with the channel, even just to keep software like this up and going. So I appreciate everybody tuning in tonight. I do this every Thursday night, 5:15 p.m. Arizona time. And again, I'll put links to some of the tutorials that I put together. They can be very helpful as far as dealing with these debt collectors and debt collection lawsuits. And I even have a couple on bankruptcy that can help you out. So check those out. I hope you guys all have a good night, and we'll catch you next week.